Good evening, everyone, and welcome to another edition of the Senate Committee on Commerce and Labor for the 81st Legislative Session. Madam Secretary, please call the roll.
Senator Hardy. Senator Lang. Senator Neal. Senator Pickard. Senator Scheibel. Senator Settlemeyer. Chair Spearman.
Here. Thank you. Let the record show that all members are present, and we are here this evening to work session Senate Bill 386. And Mr. Melgarejo, you want to read the digest, please?
Thank you, Madam Chair. For the record, Cesar Melgarejo, Committee Policy Analyst. Senate Bill 386 was sponsored by this committee and was heard on April 7th. The bill requires certain employers who laid off employees because of the declaration of emergency for COVID-19 to offer a laid-off employee each job position that becomes available and for which the employee is qualified. The bill prescribes an order of preference for the employer to offer such employees. The bill also requires certain employers in the event of a layoff to provide an employee who is to be laid off a written notice containing certain information concerning the layoff. The bill prohibits an employer from terminating, reducing compensation, refusing to employ, or otherwise taking any adverse action against a person who takes certain actions in relation to provisions of this act. The bill authorizes employees, a designated agent or representative on behalf of employees, to bring a civil action in a court of competent jurisdiction. This establishes a rebuttable presumption in a civil matter concerning the requirement for certain employers who purchase or otherwise acquire another employer that laid off certain employees covered by this act. Finally, the bill establishes minimum labor standards and does not preempt or prevent employment standards that are more protective and beneficial for employees. And Madam Chair, there is a mock-up that's been uploaded to Nellis, and I believe the sponsors of this bill and the amendment are ready to present the mock-up.
Thank you. Committee members, do we have any questions? Would you like to make a statement, Madam Majority Leader? Okay.
If I may, Chair. Good evening, Chair Spearman, members of the committee. It's good to be with you this evening. I would note that we do have for the committee's consideration proposed Amendment 3439 to Senate Bill 386. Chair, I am joined virtually by several individuals who I think can help walk through the provisions of the amendment and then answer any questions that members of the committee may have. We are joined this evening via Zoom with Paul Moore, Dee Taylor, Bob Ostrovsky, and Kevin Benson from the governor's office. And Madam Chair, I thank the committee for being able to hear the amendment on this bill, which I believe to be an important piece of legislation as we're sort of coming out of the COVID pandemic and trying to put ourselves on the pathway towards economic recovery, both in terms of ensuring that we are supporting our workers and also supporting so many of those employers that have kept this economy going and we know are such an integral part of the fabric of this state. With that, I can't thank all of our resorts and partners who've been working on this, the Culinary Union and the governor's office and the leadership of the governor in helping to get to a place where I think we have a structure that will allow for workers to return to work and also help those employers get back on track. So with that, Madam Chair, what I would like to do is turn it over to our presenters on the Zoom to walk through some of the provisions that you see reflected in the amendment, and then we would be happy to take any questions from the committee, as I know that the amendment was recently posted, and so I think it would be helpful to just do a little walkthrough of what's contained in it.
So, any particular order?
I see on the screen that we've got Paul Moore and Dee Taylor, but I don't know if Mr. Moore or Mr. Ostrovsky or Mr. Benson maybe wants to go first. Kind of leave it up to them.
I'm happy to walk the committee through the amendments that are in the mock-up, and I appreciate the opportunity to do this. I want to particularly thank the Nevada Resort Association, Virginia Valentine, Bob Ostrovsky, Ellen Whitmore for working with us really tirelessly for the last month and a half now, since the April 7th meeting, to look at this bill top to bottom and to find places where we can come to common ground on what I think are a series of improvements to it. Again, the purpose of the bill is to ensure that there's a pathway back to work for the many thousands of employees in affected businesses in Nevada who have been laid off as a result of the pandemic. Does not require that any work be created. It simply provides that for those who have worked in the position or in a similar position previously, there is an opportunity to return to their previous jobs. I will briefly go through the major amendments that are in what you have before you, and then certainly Bob Ostrovsky is here at the hearing, can also jump in, as well as Kevin Benson. The first change you'll find in section 4, which is on page 5 of the mock-up, and you'll find two changes from the original version. The first is to make clear that this bill does not grant additional authority to subdivisions of the state, to cities or counties, to adopt their own rules on recall or their own ordinances. The idea is that this state bill for the counties that are affected by it would be the standard that would be followed. So there would not be a risk of inconsistent standards. The second change to section 4 is to recognize that where there is a collective bargaining agreement in place that provides for recall rights, which are frequently more detailed and more protective than those that will serve as a baseline in this bill, that those collectively bargained recall rights will prevail in the event of a conflict. That's again to ensure that those that are subject to those collective bargaining agreements, both employees and employers, are not subject to inconsistent standards. There were several changes that are being proposed for definitions within this bill. First, on page 6 in section 10, there's a clarification that the requirements of recall do not apply to gaming establishments that are operating under a restricted license, that these obligations solely apply to those operating under unrestricted licenses. There's a clarification that this will not require the recall or rehiring of managerial or executive employees, and provides a standard based on a well-established exception to the Federal Fair Labor Standards Act for those who are acting in an executive capacity. That's in section 12. In section 13, we have proposed an amendment to remove any potential liability for officers or executives of a corporation as opposed to the business entity itself. Then moving to page 7, we have clarified the definition of resort hotel to encompass a number of properties that were grandfathered into the definition of resort hotel in 1997, and that may not meet the current definition of a resort hotel, but would be covered by this bill, notwithstanding, based on that grandfathering. There's a definition of a restricted license and a restricted operation in section 18.5. That simply refers to the definitions in the Gaming Control Act. In section 20, paragraph 3, we have proposed replacing broader language about the languages that notifications to employees must go out in, to require that the notifications be in Spanish, English, and any other language that's spoken by 10% or more of the employer's workforce. Turning to page 8, we have an amendment in paragraph 4, subparagraph C, for an additional type of notification to go to employees along with the notice of their layoff and the effective date of their layoff, and a summary of their rights to reemployment. And that's contact information for the person that the employer designates as the individual to receive complaints from employees if they believe that they have had their rights violated under this act. That will become the relevance of that will become clear as I describe the enforcement mechanisms that are being proposed. Moving down to section 22, in the original version of this bill, the requirement for covered employers was that they offer open positions to laid off employees who either held the same or a similar position prior to their layoff, or who could be qualified to work in the position with the same amount of training as any other hire. The amended version of the bill would only require that covered employers offer open positions to laid off employees in positions that are the same or similar to those they worked prior to their layoff. So it removes the section requiring that open positions be made available and offered to laid off employees in positions that they didn't previously work, but that they could become qualified for. Turning to page 9 of the mock-up, we, in paragraph 4, we had quite a bit of discussion about how to make this recall process as efficient and timely as possible, since business is picking up and there's an interest on the part of all employers to make sure the positions that they have open get filled. The original version of the bill would have given employees 10 days to respond to an offer of an open position. This amended version would reduce that to 24 hours time after they receive the offer. It would also require that the laid off employee be available to return to work within 5 calendar days after they accept the offer, meaning that in total, the maximum amount of time between the offer being received and the return to work would be 6 days. It also makes clear that if an employee, a laid off employee, either does not accept or declines the offer within 24 hours, or if they are not available to return to work, that the employer can move to recall the next person with the greatest length of service for the covered enterprise. And in all of this, the bill as originally proposed and as amended permits employers to make simultaneous offers to employees, conditioned on the ultimate job going to the one with the most seniority. So these are all mechanisms to ensure that this process of having a fair means for laid off employees to return to their jobs does not unduly delay the hiring process that employers have. We've added a new provision proposed in paragraph 6, which addresses situations in which a laid off employee either does not respond or declines offers of employment. That section states that an employer does not have to make continued offers of open positions to a laid off employee if the employee states in writing to the employer that the employee is not interested in future job openings with the employer, or if the employee states that the employee is not interested in future job openings with different hours than what they worked prior to their layoff. That addresses the situation in which an employer offers full-time work to a previous part-time employee. That part-time employee states to the employer, I'm not interested in full-time work. And that would allow the employer to discontinue making further job offers for full-time work to that employee. Next, if the employer extends 3 bona fide offers to a laid-off employee, and each of those offers is rejected, then the employer can discontinue making further offers. A bona fide offer of employment is one and the same or a similar position as previously worked, with at least 3 weeks between each offer, and which with the offer having the same amount of regularly scheduled hours as were previously worked. And then finally, the employer is not required to continue making offers of employment if they attempt to make 3 offers of employment to the laid off employee, and each offer is returned as undeliverable if by mail, returned as undeliverable if by email, and if the employer uses a telephone or text message, the number provided is no longer in service. We have made some changes to, proposed changes to Section 24, which is the method of enforcement. Previously, the original version of the bill was enforceable only by private right of action by an aggrieved employee. As proposed to be amended, the bill would allow an aggrieved employee either to file a complaint with the labor commissioner or bring a civil action in any court of competent jurisdiction. We have proposed removing what's really extraneous language in Section 24 about bringing actions on behalf of other employees, private actions on behalf of other employees. And we've done that because Nevada Code of Civil Procedure Rule 23 provides the basic rules in Nevada for class actions. And this bill, as proposed, would not amend those basic procedures. We've also added a proposed amendment that would create a process that would have to be followed by a laid-off employee before bringing a complaint with the labor commissioner or filing a civil action. And that process would involve the employee providing the employer with written notice of the alleged violation and any facts that are known by the employee to support the allegation, and then affording the employer 15 days after receipt of the written notice to cure any alleged violation. So that would be a precursor to being able to file either a civil action or a labor commissioner complaint. Further down on page 10, in paragraph 3 of section 24, we've proposed some changes to the rebuttable presumption in the event of a allegedly retaliatory act. We have removed in subparagraph B the reference to an employer refusing to employ someone in alleged retaliation for asserting their rights. And we've made that proposed amendment to avoid the implication that anyone who asserts rights to recall is then entitled to a rebuttable presumption. The rebuttable presumption would still apply in the event that a laid-off employee asserts their rights and is then terminated from a position, demoted, or otherwise had an adverse action taken against them. On page 11, in paragraph 5, we have modified the remedies that are available to include many of the same remedies as were in the original bill, but we've changed 2 elements of them. The first is that we have proposed adding a civil penalty, a baseline civil penalty of $100 and an additional civil penalty of $500 payable to the employee for violations. And also, instead of making an award of attorney's fees mandatory in the event that a plaintiff prevailed, that would now be discretionary on the part of the labor commissioner or the court whether to award attorney's fees. Finally, with regards to the original SB 386, on page 13, section 26, in paragraph 2, we have proposed adding language that makes clear that the act does not apply to a laid-off employee who is party to a valid severance agreement. So if an employee received severance in return for their layoff, additional money, and signed a severance agreement, then the recall rights would not apply to that individual. As relates to the original SB 386, the original version of the bill would have had the bill sunset on the later of the date that the governor terminates the emergency declaration of emergency for COVID-19, or July 1st, 2023. If you will turn to page 20, you can see in section 29 that the provisions on recall would expire on the later of the date that the declaration of emergency is terminated, or August 31st, 2022. Those are the main proposed amendments to the original SB 386. The remainder of the mock-up are proposed amendments to SB 4 from 2020, which I'm happy to describe or to turn over to Bob to describe.
Yeah, that's fine. Madam Chairman, members of the committee, for the record, Bob Ostrowski, O-S-T-R-O-V-S-K-Y. I'm here today on behalf of the Nevada Resort Association, made up of 77 member hotels, out of about 175 licensed facilities. The language found in the later sections of the bill relative to SB 4 make changes which are consistent with the new CDC guidelines and consistent with the caseloads and positivity rates in the state. It does not repeal SB 4. There's still a number of other items included in SB 4 that provide protections for employees and make sure we have adequate cleaning standards to protect both our employees and our customers. But it does, in fact, remove a number of the sections which are now no longer consistent with the CDC guidelines. I think the legislature attempted at the time to do the best it could with the information it had in kind of a dark period of our history. And we were able to comply with those through that period. But given the fact that the governor has loosened things, the local governments have been able to apply new rules. We think these changes to SB 4 are appropriate. I might add before the others comment that the association back in February of 20, not the association, but the industry, employed almost 350,000 employees. By April of 20, that number had dropped to 204,000. And I would consistently believe it probably dropped below that as time dragged on. So Clearly that and the indirect effect on employees who serviced casinos that did not actually work there. The estimate from Applied Analysis is about 66,000 jobs. Made these kind of negotiations a little difficult. We certainly have to think about in terms of the masses of employees and the masses of paperwork that are required here. But I got to tell you, our members care. Experienced and dedicated employees are what make these operations work. It's one thing to build $1 billion building. To operate it, you really need a well-honed team. So we were glad to be able to come to some improvements in this language. So the association officially, on a majority position, is neutral, and we will not. We don't support the bill, and we will not work against the bill. As an association, we are neutral. We appreciate the efforts of the governor's office, members of the culinary union, detailer, and others through some hard negotiations. I mean, if you're environmentally conscious, this was not a good time for you. We must have killed a tree and used a terabyte of storage to get here. But we did get here, and we are hopeful that given the amount of business and the situation as it arrives today, that most, if not all, these employees will come back to work very quickly, long before we get to the dates that are in this bill. We know we've employed a lot of folks. There's a lot of hiring going on. There's a lot of positions we can't fill. Recognition that the industry always had a relatively high turnover rate, so we quite expect a number of these employees we offer positions to are no longer either in the Las Vegas area or they took other kinds of jobs. So we'll be continuing to recall under these procedures, at the same time finding new employees to fill jobs, as well as competitive situation. We all know there's another major hotel casino opening on the Strip next month. It all creates pressure for experienced, qualified employees, and we will do our best to follow if this is adopted as policy of the legislature, to do our best to fulfill its obligations. Thank you.
And with that, Madam Chair, I think we do have everyone else available to answer any questions that the committee may have at this point on the amendment that was just walked through with everyone.
Thank you. Questions? Senator Settlemeyer, and then Vice Chair and Senator Lang.
Thank you, Madam Chair. I was just curious. This seems to be a little bit lengthy and onerous for especially small businesses. Was there any discussion of a small business exemption maybe for businesses below 50?
Madam Chair, Nicole Cannizzaro, Senate District 6, for the record. I will defer to any of either Mr. Moore or Mr. Ostrovsky, but I don't believe that has been part of the conversations. But I would defer to them if there's additional information they may have on that.
Feel free to go direct.
Thank you, Madam Chairman. Bob Ostrowski. No, we did not have any discussions about that. This bill, as drafted, of course, covers employers who have establishments within the bounds of a non-restricted licensee. So if you have a food court or you have a restaurant, these apply.
I do want to point out that the definitions here, the hotels that are covered are going to be those with 200 or more guest rooms that qualify as a resort hotel, or that don't qualify as a resort hotel, but nonetheless have 200 or more guest rooms. The event centers that are covered are going to be those with at least 50,000 square feet or more than 5,000 seats. The licensed gaming establishments are those with unrestricted licenses. So there isn't an explicit small business carve out, but the definitions of the covered entities was intended to have this apply to the larger establishments in the state.
Thank you, Madam Chair. But in that respect, some of these entities operate those smaller establishments as sub-businesses independently. Will the entire business be utilized? Or again, because you could have a small faction running the restaurant, which may only have, 30 or 40 employees, and this could be very problematic. But I guess you're saying that it would apply to everyone due to that it's part of the whole business. Is that correct?
Both in terms of the hotel and in terms of the licensed gaming establishment, the requirements would apply to contracted, leased, or sublet premises. So not just any business, but only those that have contracted, leased, or sublet to the larger establishment.
Thank you, Chair. I find that troubling.
Vice Chair?
Thank you, Madam Chair. So I had a question to the attorney. What's his last name? Ben? Moore. Okay. All right. So I had a question on section 24. All I can say is just wow. So when I first read it, I was thinking, okay, well, maybe we're going tit for tat here. So in section 24, where this is the rebuttable presumption piece, and it was sub 4, which then ties back to subsection 3 about the legitimate business reason. So legitimate business reason was in the original language, but when I reread this about how you tie it back, which is in subsection 3, I guess I'm wondering how an employee is going to fight back under that actual provision, because the bill, I understand what the bill was doing, which is to get workers back to work. But when you have the legitimate business reason tied, you're kind of baking in affirmative defenses to me. And typically, when you have a legitimate business reason, the court gives the highest deference to that legitimate business reason, which will offset any other defense that an employee may bring. And it's just, I guess I wanted to understand more about, the negotiation around this language, because if I was going to argue something and then it's already established that the business can say, well, what was the legitimate business reason for why I did this, I might as well put my checkbook up and not pay for this court case, because I'm almost guaranteed to lose, because the defense that I have to overcome is probably going to be super difficult for me to overcome. And so I'm just wondering, in terms of workers' rights, are we setting them up to pretty much go home with a lost case? And I understand that potentially why business would have wanted this in there, which is called a guaranteed, I'm going to win. But can we talk about this? Because it's disturbing.
Sure, and I appreciate your question. So just to be clear, this language on a rebuttable presumption only applies in instances where there's an allegation that an employer has retaliated against someone for asserting their rights under this act. So it's solely applied to those types of allegations. The normal way in civil litigation that things proceed is that the plaintiff, in this case the employee, has the initial burden of proving their case. In certain contexts, a burden shifting framework has been adopted. The best known of these is in the Title VII discrimination context, where the McConnell-Douglas burden shifting procedure is used for making determinations of discriminatory conduct. And the idea behind it is actually quite protective of workers. The idea behind it is that frequently an employee will not know all of the reasons why an employer made a decision to terminate them. And so what this does is it puts the burden on the employer to explain the justifications for the termination if the termination was done close in time to the point at which the employee asserted their rights. So there becomes then a initial presumption that the action was retaliatory, and the burden shifts to the employer to prove that in fact it was a legitimate business reason. So it's modeled off of a quite well-known burden shifting system called the McDonnell-Douglas test in the Title VII context. And the intent, and we expect the effect of it, should there ever be a case of this nature, and that's certainly open to question. We don't expect employers to retaliate against employees for asserting their rights, would simply mean that that employers would have to lay their cards on the table if there's an allegation that they acted in a retaliatory manner.
Madam Chair, can I have a quick follow-up? So thank you for that, because it's interesting that you said that in this McDonnell version, but when you read section 24 sub 3, right? And so I'm gonna walk you back through this, because I heard what you just said. So you look at section 24 sub 4, which then line 6 takes you back to subsection 3, and then the line subsection 3 takes you then back to sub 3, which talks about the violations in sections 23 of this act. And then when you read sections 23 of the act, which then references seeking to enforce any lawful means of his or her rights pursuant to sections 2 through 28, the way I read that was the employer will then be able to assert a legitimate business reason for sections 2 through 28 if an employee then wants to challenge. And I guess the thing that's concerning is that typically you have several defenses that you can play out, but then you put in the pretext language, but there is no pretext argument when you state legitimate business purpose. Like, it doesn't actually exist. Like, you can make the argument and you're probably going to get laughed at because the pretext means that something else occurred. And I guess, hey, listen, it's not my bill, but I just think that I think that this is creating a very heavy burden for an employee, a casino worker, to have to overcome. And it's not fair to me, right? This is so difficult for me, because when I first saw this bill, I was super alarmed at so much. The ability to do its class action. And now I see this and I'm saying, okay, well, this is not even a fair fight. In a discriminatory pattern, legitimate business reason will kill your arguments all the time. I know this because I've had to, talk about this or talk about discrimination or teach discrimination. And I'm telling you, I know that that's a very hard burden to overcome. But I got my questions out. I appreciate it. I'm just going to mind my own business.
Is there a response? Yes, sir.
I'm happy to go into that section in more
Excuse me,
detail
sir.
if there are questions on it.
Excuse me, sir. Do me a favor. Just state your name so the secretary can keep up.
Thank you. Paul Moore with McCracken, Stemmerman, and Holsbury. I'm happy to go into more detail about that section and to respond. We've crafted it in a way that we think is a balance between the need in situations of retaliation to ensure that employees have all of the facts that they need by having an employer have to justify the termination or the alleged retaliatory act in the first instance. Ultimately, regardless of the context, if an employer has a legitimate business reason, one that is not retaliatory, for taking the action that they did, then civil liability is not going to apply, whether that's discrimination or, in this case, retaliation for someone enforcing their rights under the Act.
Good.
I'm good, Madam Chair.
Senator Lang.
Hi, thank you for being here today. Thank you, Majority Leader, for doing this bill. And I really appreciate Culinary and the Resort Association and the Governor's Office for working together to do something that's going to help Nevadans get back to work. My question more has to do with getting the people back to work in that process. So as I read the bill, well, first of all, what capacity are we at right now for on the resort corridor?
I'm going to defer to Dee Taylor on that question.
Hi, Madam Chair, Dee Taylor from Unite Here International Union. In our capacity, I can't speak for the entire workforce. Mm-hmm. It's about 55%. And that's due to the fact that the weekends are good, but obviously some of that midweek is weaker since we still have not gotten the international travel and the business travel back. So we're still far short of where we were pre-pandemic.
So, Mr. Taylor, what I'm concerned about, I guess what I have a question about is like, MGM, for instance, just to use MGM as an example, they have many properties. And so in your process, are you going to call people back on a property basis or on the MGM basis?
Well, I can speak to that. That would be done. I speak for the folks that we represent. That's done on a property basis, and that's how, as Paul had laid out earlier, about the obligations of those who have more detailed obligations than what's in this bill, that would apply. So in that case, in your question, they would get called back to their particular property.
And then, may I keep following up? And then if they're called back, and just for an example, just say that X property doesn't have any people they haven't called back in that position because they've left and gone other places, but that group MGM would have in a pool, let's say, people that could be available to fill that position. Would you then go to a pool from another property within that group, or does it just open up?
I can speak about MGM because I'm familiar with it. They generally don't like to have people work in different properties for a variety of legal reasons. And so generally they bring back those folks from that particular property, and then they open up, if there are not enough employees, then they open it up to whomever. But they don't transfer people between properties for legal reasons, which I certainly don't feel like I should talk about since that's a company, but has been explained repeatedly due to DOL audits, et cetera.
So one last question then is, how long do you anticipate that it would take to get people back in their jobs?
Well, I wish it was yesterday, but I think that's really relying on three different things overall. I think this bill will be extremely important to get those folks back who, for no fault of their own, have been not brought back due to the pandemic, and not start over as new employees. We have cases where people are 20 or 30 years at a property, and the companies have used this to frankly say they're terminated, and then they can come back and reapply, but they lose those 20 or 30 years, which you can think about those complications. But we think it's going to take a while, just like we look at all the industry, we listen to the industry. I think business travel is absolutely essential to get back. I think conventions are absolutely, entertainment absolutely necessary, international travel. So if you put those all together, I think hopefully by sometime, frankly, a year from now, we would be back completely. Now, at the same time, things change. No one ever anticipated this pandemic, but we're overly optimistic that with the vaccine available, with people feeling safe, business will pick up. That certainly happened with leisure travel. That has not overall happened with convention and business travel, and it certainly hasn't happened yet with international travel either.
Thank you. And just, excuse me?
I'm sorry, Madam Chairman, this is Bob Ostrowski. If I could just help to respond to Senator Lang. I would expect when this is all said and done, about 70% of the employees who lost their positions will eventually return. We know just because of our turnover history, we won't get all those employees back, but the other 30% of the jobs will be filled by new referrals from the union hall if you're a union property, if you're not, through regular hiring. Remember, this covers not just union employees, but all the employees in the facility, non-union and union. So we'll never see 100% of our people back, hopefully, and I agree with Mr. Taylor. International travel, conventions that return are the key to the success of the industry, the success of the state, and the success of our employees. I mean, there's just no way around it. Thank you.
And I would just add, finally, I think this bill is really important because it provides a roadmap, not only for the union and the employees, but also for the resorts, and that everybody can agree this is the roadmap, this is what we're going to follow. And it helps the employees who are laid off right now to know that they're going to have an opportunity to get back to work, and this is how it's going to happen, because it's been difficult for everyone. And I know that Senator Settlemyre mentioned small businesses. You know, small gaming taverns and businesses have been disproportionately affected, just like the Resort Association. And I think that, and the employees at the resort. So I think this is a great roadmap, and thank you for bringing the bill.
Thank you. Committee, additional questions? So seeing none, let's go to the phones. And I'm sorry, anyone in the room that is here in support? Oh, that's right. You're right. I'm like, okay, got you. This is a work session. This is a work session. This is a work session. All right, got it. Okay, seeing no questions, I'll entertain a motion.
Amend to pass?
Second?
I have amend to pass from Senator Lang, second from Senator Scheibel. Additional questions? Yes, ma'am.
I don't have a question, but I just wanted to comment that I want to commend the Majority Leader, Culinary, the Nevada Resorts Association, and all of the other stakeholders that came together to come to a consensus on this bill. I understand that it was a hard-fought consensus, and I'm really happy to see that the bill is in a place that we can move it forward, because I agree with my colleague, Senator Lang, that it's really important that we have a path forward to ensure that people are able to get back to work in Nevada, and so I want to thank you for all of your efforts on this.
Additional questions? Vice Chair?
Thank you, Madam Chair. So, ditto that response. I understand that, hard policy takes a lot of negotiation, but I am super hoping that Section 24 and any language in the future, I guess, if I see any retaliatory cases, or not cases, but bills that come through, that we don't see a repeat of Section 24, because I think I'm just going to be watching out for all that language in the future.
Additional comments? Senator Pickard?
Thank you, Madam Chair. I like where this has come. I'm still deeply troubled by the rebuttable presumption. I think in many respects this is better than some of the CBAs I've reviewed in the past. And this is applying to non-union shops that don't ordinarily have to deal with these. I think it's going to be a significant burden. So I just can't, I still think, although we've come in a good direction, I don't think it's come far enough for me to be able to support the bill. Thank you.
Thank you. Questions or comments? Okay. Madam Secretary, please do a roll call vote.
Senator Hardy. Senator Lang.
Yes.
Senator Neal. Senator Pickard. Senator Scheibel.
Yes.
Senator Settlemyre. Chair Spearman.
Here? I mean, yes. And so let the record show that the motion does pass. And Majority Leader, you want to take the floor statement on that? Okay. All righty. Thank you so much. We'll move now, and thank you all for joining us in the on Zoom in the Brady box. We're all getting used to that. So thank you all. Appreciate you taking the time to do so. With that, let's go to public comment. Broadcast, anyone on the lines for public comment?
Thank you, Chair. Currently, your public line is open and working, and you have no callers at this time.
Okay. Let's give it a couple of seconds and make sure they're not having difficulty.
Thank you, Chair. Standing by.
Still no one?
Chair, your line is still open and working, and you have no callers at this time.
Okay, thank you, thank you. Mr. King, Senator Settlemyre just came back. I think we can record his vote for the bill, yes? No? No? I'm just asking.
Thank you, Madam Chair. For the record, Will King, Committee Counsel. If Senator Settlemyre would like to vote, he can vote.
I appreciate that. Not to shock everybody, but I think I'll be a no. Thank you.
Okay, and with that, I think that's all the business that we have this evening. Committee members? All righty. Well, we will adjourn this edition, and please stay tuned for the rest of the week. We may wind up doing this again and again and again and again and again some more. So just stay tuned, and this is the time of the session where we have to really be flexible, okay? So thank you all for joining us, and we are adjourned.